Hey folks, welcome to the Four Boxes Diner. I'm your host, Mark Smith, proud American gunner, constitutional lawyer, and member of the United States Supreme Court Bar. If you haven't subscribed to this channel, please do so and show your love for the Second Amendment like we love it here. We have a very special Four Boxes Diner event today. We have none other than the famous attorney from Washington, D.C., David Thompson of the esteemed law firm Cooper & Kirk, one of the major law firms in America, and David's one of the top lawyers in America. He's argued multiple cases before the United States Supreme Court itself. He, too, is a member of the Supreme Court Bar, and his law firm is constantly before the Supreme Court, including, most importantly, on issues involving guns and the Second Amendment and all that. And we're going to talk to David about the BRUEN case because, among other things, David's law firm and David commenced the NYSRPA versus BRUEN case at its very beginning. So we're going to have the luxury and wonderful privilege to talk to David about how the NYSRPA versus BRUEN case came to be, what it means, and some of the other history associated with the scholarship, the text, the history of the Second Amendment, especially as interpreted by courts. So we know what's going to be coming down the pike as we talk about the Second Amendment, not just here on the channel, but across the United States. David, welcome to the Four Boxes Diner. I cannot be happier that you're here. I think the last time we spoke in public was at a Federalist Society event with Jonathan Lowy at the Brady Center back in November, and I'm glad to have this conversation with you in light of the fact of your critical role in this major win involving NYSRPA versus BRUEN before the Supreme Court of the United States.
Well, Mark, thanks so much for having me on the show. I've been an admirer for a long time of this channel, and it's great to be with you.
So, David, let me just start with the most obvious question for the viewers here, which is, you've been dealing with BRUEN from the beginning. Should we think this is a big deal? Is the Supreme Court win a big win or not a big win? What do you say?
This is a huge win. This is a historic and indeed monumental win for those who care about the Second Amendment and the right to keep and bear arms. This is the first time in United States Supreme Court history that they've ever addressed whether there is a right to carry a firearm, and this is an unequivocal victory for those who want to be able to carry a firearm for self-defense outside the home.
David, do you think the Supreme Court got the decision right?
I do. I think they did a magnificent job. It's important practically because now all law-abiding Americans will have the right to keep and bear arms, including outside the home. But they made an important legal change, too. Lower courts, these liberal judges in liberal states, had been consistently upholding gun control laws across the country. And they had a lazy logic. It was in two parts. First, they said, they looked to see, is this within the historical meaning of the Second Amendment? And they should have stopped right there. But they go on to say, well, yes, it's within the historical meaning, but the legislature tells us this relates to public safety. We're going to defer to the legislature, and voila, your constitutional rights have been erased. And these judges and these states were trying to erase the word bear from the United States Constitution. And Justice Thomas and the other justices that joined his opinion said that is improper. It's in the text, and the text creates a right, and it's an unqualified right. So I think the Supreme Court did a great job.
So, David, it's quite interesting that if you read the text of the Second Amendment, it does talk about multiple rights. It says the right of the people to keep and to bear arms shall not be infringed. I guess the question is, why has it taken so long for this Supreme Court? They decided Heller and McDonough in 2008 and 2010, where they said that we as Americans have an individual private right to have a loaded firearm unlocked in the home for the purposes of self-defense. Why did it take so long for the Supreme Court to actually address the second part of the Second Amendment, the right to bear arms?
Well, let me give you just a little bit of history. These things take a long time. Obviously, it was from 1939 to 2008 that the Supreme Court went from addressing the Second Amendment explicitly. And indeed, it was in a case called Emerson, decided by the Federal Court of Appeals with jurisdiction over Texas and Mississippi and Louisiana, that, this theory that there is an individual right to keep and bear arms was first acknowledged and articulated by a federal court of appeals. That was in the late 90s. It took another 10 years for the right to possess arms to be upheld by the United States Supreme Court. Then it took 2 years for the McDonald case for the court to say, and that right applies to the states through the 14th Amendment. And then 2 years later, we brought a suit against Illinois, which was the only state in the Union with a complete and flat ban on carriage. That was struck down. Then we turned our attention to these so-called may issue jurisdictions, places that said, well, we may give you a permit if you have a special need. And in 2017, 5 years after that Illinois decision, the D.C. court struck down D.C.'s law. At that point, we had different courts in Massachusetts, New York, New Jersey, and Maryland that had upheld these types of laws, which were de facto bans. And a court on the one hand, and on the other hand, the D.C. court. And so at that point, we had a split in the courts. And we felt very confident at that point that we should get the United States Supreme Court to take this case. We refiled in all those jurisdictions saying, hey, you need to rule against us under circuit precedent, but please do that quickly because we want to go to the United States Supreme Court. The court in New Jersey moved with the most alacrity, and it got to the Supreme Court in 2020. And much to the dismay of myself, who filed that suit, and others in the Second Amendment community, the cert was denied. The Supreme Court declined to take that case. And then Justice Ginsburg died. Justice Barrett came on the court. The exact same issue came up from New York, and cert was granted. And so it takes time sometimes for these things to develop. The Supreme Court likes things to so-called percolate, but also personnel is important. And without the 3 Trump justices, this decision never would have come out the way it did.
So, David, that's a great observation about the Trump justices, of which there are 3 of them. There's, of course, Justice Neil Gorsuch, Amy Coney Barrett, and, of course, Brett Kavanaugh. So, David, to what degree, does Donald Trump deserve credit for his role in nominating these justices to the Supreme Court?
He deserves a huge amount of credit because this wasn't an accident. He said he wanted originalist judges who weren't going to make up rights, were going to make up laws. Instead, they were going to focus on the text and the history. And that's exactly what Justice Thomas did. And that's exactly what Gorsuch and Kavanaugh and Barrett, the 3 Trump justices, did. So I really give the former president a lot of credit for his judicial nominations. They're terrific.
But David, you've used the word originalism. For the benefit of our audience, what exactly is originalism? And it's interesting, if you look at some of the television channels that are run by, I would say, more left-leaning individuals, they seem to basically make fun of the notion of originalism. They seem to make arguments like that the Constitution should evolve, it should adapt to modern times, things like this. So perhaps you could talk to the audience a little bit about what is originalism and why should they, if they support the Second Amendment's right to keep and bear arms, why should they embrace this notion of originalism?
Well, originalism refers to looking at the text of the written document. That's what the founders crafted. That's what we as the American people agreed to. Our ancestors, forefathers, agreed to be bound by that document. And you look at the public meaning, which is why the history surrounding the time of the founding is important. So you're not just consulting dictionaries. You say, okay, and what did people understand those words to mean at the time of the founding? And it's not frozen in time. The First Amendment, which says Congress shall pass no law abridging the freedom of speech, applies not just to books, but to the internet. And likewise, in the Second Amendment, it's not just the arms that were in creation at the time of the founding, but modern arms as well are also protected. But here's the key. You apply it to modern day circumstances by analogy. By analogy. The left would just make up rules and just be like a 9-headed Caesar, Justice Scalia once said, giving their collective thumbs up or thumbs down to suit their fancy. And that's not right. You have to have an analogy. And the reason why originalism is good for those who care about the Second Amendment, at the time of the founding, there were not that many restrictions. There were some. You could not bring a gun into a courthouse. You couldn't bring a gun into the Maryland General Assembly. You couldn't bring a gun to a polling place. Okay, so there were some restrictions, but it was nothing like what we see today, complete and total bans on the right to carry. And so that's why it's very good news, because this is going to create much more freedom and it's going to restore the vision of the founders. One of our great Supreme Court justices was Justice Joseph Story. He is widely respected by every member of the Supreme Court, and he said that the Second Amendment was the palladium, was the cornerstone of all liberties. So for those who care about liberty, this was a great win.
But David, on this channel, we've actually spent quite a bit of time, because here at the Four Boxes Diner, I work really hard to try to educate the viewers about sort of the history of the Second Amendment as really articulated by scholarship and the scholars. I try to give them the information they can find in other places, because sometimes it's hard to find and it's obscure. And I try to give them that information both from a scholarship point of view and a history point of view. So I guess the question is, in light of that, one of the things that we've talked a lot about is this concept that the left and the anti-gun community seems to love, this notion of tiers of scrutiny, which, as I've always seen it, when I see the words tiers of scrutiny, intermediate scrutiny, strict scrutiny, it's really just a euphemism. It's a metaphor for balancing away your rights. That basically it allows judges to say, well, the government has these really important interests on the one hand, and Mark and David have a right to keep and bear arms on the other hand, but we basically are going to always rule in favor of the government when we balance these interests out, because that's just the way we do it. So can you talk a little bit about the notion of tiers of scrutiny? Should gun owners love or hate this? And what does this BRUEN case do to the notion of tiers of scrutiny versus other standards of review, which is how, of course, judges decide Second Amendment and other constitutional cases, by applying a criteria for deciding these cases?
Well, people who care about liberty and who love liberty should not like the tiers of scrutiny, because as you just indicated, Mark, you have clear text that says things like the right of the people to keep and bear arms shall not be infringed. How much clearer could we say that? If we all gathered together and we wanted to create an unqualified right to protect ourselves with firearms and self-defense, that is the sort of wording that you would come up with. And what tiers of scrutiny does is it says the judges look at those words, but then they can eviscerate, they can erase the meaning of the words by saying, yeah, but there's something else that's more important. In whose opinion? The judge's opinion. And that's not right. Justice Thomas said, and he was echoing what was said in Heller, the Second Amendment is itself the product of interest balancing. The founders weighed all of the interests. They were aware of crime. They were aware of crazy people. They were aware of danger and murder. And they said, in light of all these circumstances in human nature, we're going to give this right, this unqualified right, to the people.
So, David, before I want to ask you a series of questions about what does this decision mean for other gun control laws that are out there. But before we get there, perhaps you can just tell us a little bit about your experience in history in actually starting the BRUEN case in New York. What were some of the thinking that went into that? What was some of the observations? What motivated? What are some of the sort of the story? Obviously, we know the ending, and the ending is a spectacular, tremendous success in favor of the Second Amendment. But tell us a little bit about what the thought process was at the time NYSRPA versus BRUEN was commenced.
Well, there were so-called petitions for a writ of certiorari. These are requests for the United States Supreme Court to take up a carriage case. When the Massachusetts ban was upheld, we filed a petition on that. The New York, the New Jersey, the Maryland, all of these bans had been upheld, and the Supreme Court had declined to take a case, presumably because there weren't 5 of them who were committed to an originalist understanding, and the liberals were worried about taking it too. So neither side was taking these cases. We tried to force their hands by filing in D.C. We won in D.C., but then the District of Columbia, even though there was this circuit split, did not try to take the case up to the Supreme Court. And let me just say for your viewers, one of the main criteria the United States Supreme Court looks at in trying to decide whether to take a case is whether the same law, here the Second Amendment, has different meanings in different places. They don't like that, understandably. Second Amendment should mean the same thing throughout the country. And after our win in the Grace case, the Wren case, in the D.C. Circuit, the Second Amendment was being interpreted differently. So we thought we had a great chance to force the United States Supreme Court to take the case, because now, even under their own criteria, which look at a circuit split, we satisfied that. So we refiled in Massachusetts, New York, New Jersey, Maryland. We didn't know which would be first. Candidly, we didn't care. And as I indicated a little earlier in the show, I said to all these courts, hey, you have to rule against me. Under your binding appellate precedent, I lose, okay? But do it quickly because I'm going to get you reversed in the United States Supreme Court. And so, it's great when a plan comes together. This is an instance when a plan came together. And as I indicated, before Justice Barrett got on the court, the first case to get there was New Jersey. They declined it. I think that tells you everything you need to know about the importance of the Trump justices. The fact that it wasn't until that third one got there, until Ruth Bader Ginsburg was gone and Justice Barrett was in, that we were able to convince the court, take the case. At that point, the conservatives apparently felt like, okay, we've got the votes, let's take this up and let's decide this once and for all.
Now, David, there's another case that we don't talk a lot about. It's kind of been lost to history in a way, mostly because of the 2020 presidential election, the elevation of Judge to Justice Amy Coney Barrett, and all the different events that have occurred in American history, including NYSRPA versus BRUEN. But, there was a prior NYSRPA case, I believe it was NYSRPA versus New York City, that was granted cert. It was actually heard by the Supreme Court, and it kind of disappeared. So can you talk a little bit about that first NYSRPA versus New York City case that has sort of been lost in the sands of time? It wasn't that many years ago when this case was addressed by the Supreme Court.
Yeah, that was a very great point, Mark. That was a very narrow issue. The Supreme Court had taken it up. The question was, do you have a right to carry a firearm from one home to another within the state of New York? And New York City said, no, you can't even do that. And so it was a very draconian law. And, once the Supreme Court took the case, then the New York State legislature basically undid the law strategically, right? They didn't obviously really care about helping gun owners, but they wanted to try to keep these cases from the United States Supreme Court. One of the things that, to my knowledge, is almost unique in American history about this fight that we've been engaged in with anti-gunners is that they have been disciplined. So when they lost in Illinois, that was painful for them, but they didn't take it to the Supreme Court in 2012. They were afraid of the answer they would get. In 2017, when they lost in the District of Columbia, they didn't take it to the Supreme Court. They were afraid of the answer they would get. And when the Supreme Court finally did take one of these cases, as you indicated, in 2020, then they what's called mooted out the case. They rendered it no longer basically in force or effect, stripping the Supreme Court of the ability to address the issue. This time they couldn't do that because New York was not prepared to actually allow law-abiding citizens to carry firearms in the state. And so that's why they couldn't moot this one out.
David, that we've talked on this channel a little bit about some of the strategy, because I do want to educate the viewers on litigation strategy. Sometimes to get to the outcome you want, you can't just take on a statute head on. You have to do it incrementally. You have to do it step by step, because that's how the law works. And I want to bring this up because I believe, and I congratulate you on this, I believe it was your firm that recently won a major Second Amendment case in California in the Ninth Circuit Court of Appeals, upholding the notion, the concept, which I think is common sense and clear, that 18 to 20-year-olds have a right to keep and bear arms because they're part of the people, as referenced in the Second Amendment. And of course, 18 to 20-year-olds can be drafted, they can enter into contracts, they can get married, they're full adults, really, as I see it. That's what the law mostly says. So the question is, David, usually in the Ninth Circuit, when the panel issues an order that's favorable to the Second Amendment, the Ninth Circuit has a history of unbanking that decision and basically reversing it against the Second Amendment. Can you talk a little bit about, to the extent you're allowed to talk about without violating the attorney-client privilege or anything, can you talk a little bit about, what happened in that case? Is that case going to get unbanked by the Ninth Circuit? And if the case gets unbanked by the Ninth Circuit, is that actually bad for the anti-gunners? Because that might allow really the pro-gun rights groups to seek certiorari from the Supreme Court, and that would ultimately be very bad from the anti-gun point of view, if the Supreme Court issued an order saying 18 to 20-year-olds have a right to keep and bear arms under the Second Amendment, which I think they do, but the Supreme Court hasn't yet addressed that.
Well, Mark, let me start with the merits of that dispute. I think you're right 100%. If you look at the history surrounding the adoption of the Second Amendment, the Militia Act of 1792, so just 1 year after the adoption of the Second Amendment, says that the militia includes 18-year-olds. And one of the canons of constructions, one of the principles that the United States Supreme Court looks to across the entire Constitution is they place great weight on any enactment by the first Congress to deal with that Congress just adopted the amendment. And so obviously they put a lot of weight on whatever legislation follows thereafter. So you've got the Militia Act of 1792 on the merits. I think it's crystal clear that you're going to, we should win that. But you're right. The Ninth Circuit has, and some of these other liberal circuits, has a history of massive resistance. It was the hammer of Thor, and we're going to use the hammer of Thor on any of these jurisdictions that continues to flout the plain meaning and the history of the U.S. Constitution, including the Ninth Circuit en banc. If they en banc this case and take this case, we will go to the Supreme Court. And maybe the liberals on the Ninth Circuit will think, we don't want to do that. We don't want to open the door. We've taken enough hits recently. Maybe we'll back down. So we'll see soon enough.
So, David, again, congratulations on that Ninth Circuit win. That was wonderful news. We even talked about it on this channel a little bit, and are very happy. I would like to ask you, and I'm sure our audience wants to know this. They want to know what the NYSRPA versus BRUEN decision means for various gun controls. So what I'd like to do is just kind of go through some of the most obvious ones and get your take as to what does the BRUEN decision mean on some of these. So let's just start with what I think is a relatively easy case from a pro-Second Amendment point of view, and that is these bans on so-called assault weapons, which, as you know, are really just AR-15 platforms. But of course, the media is very good. The anti-gun community is very good, and their handmaidens, the media is very good at just repeating and mouthing the words assault weapons, taking advantage of the ignorance of many people, especially those that live in urban areas that are unfamiliar with firearms and have possibly never even touched one. So tell us, what does the BRUEN case mean, if anything, for attacks or constitutional challenges on so-called assault weapon bans?
Well, the court in Heller, the Supreme Court in Heller, was very clear about the relevant test. It said if a firearm is commonly possessed by law-abiding citizens for lawful purposes, then it's protected and it can't be banned. And the AR-15, I believe there's something like 25 million of them in the United States of America. This is the most popular rifle that's being sold in America today. So by definition, it is commonly possessed. Is it possessed for lawful purposes? You betcha. Because even if every gun crime in America were committed with an AR-15, and it's not, they're committed mostly with handguns, but even if they were, it would still mean 99.9% of these were never used in a crime. That proves that they are commonly possessed for lawful purposes. And under Heller, that should be enough. Now, what these lower courts have been doing is that tiers of scrutiny, that two-step analysis, saying, okay, even if that's right, there's an important interest on the other side. Justice Thomas said, stop at step one. Stop at step one. And so whether we're talking about the AR-15s or magazines, which is a related issue in the sense of the analysis is the exact same for the magazine bans that are out there as well, commonly possessed, there are about 462 million of them in the United States, as I understand. So that's common. There again, only a tiny, tiny fraction, less than 0.001%, I believe, are ever used in a crime. So they're possessed for lawful purposes. So those AR-15 bans should fall under this, and these magazine bans should fall under BRUEN as well.
Yeah, under the Second Amendment, which I've talked about on this channel, of course, it says the right of the people to keep and bear arms shall not be infringed. That's important because of what do arms mean? And you went to Harvard undergrad, David, I believe, and Harvard Law School, so that makes you a smart guy.
I studied hard, but go ahead.
So the question really is there a historical definition of what the word arms mean at its most basic level? Before we even talk about commonly possessed arms or commonly used arms here in the United States, what does the concept of arms mean here in the United States? And could you perhaps elaborate a little bit on just that word historically?
Well, the first English dictionary was put together by Dr. Samuel Johnson, and he was a genius. He wrote this entire dictionary basically from memory with quotes and everything. And so that's the dictionary that the United States Supreme Court looks to more than any other dictionary, because there was no American dictionary until 1828 when Noah Webster put his together. They look at that one too. But Samuel Johnson described arms as anything that could be carried for offensive or defensive purposes in a confrontation. I'm paraphrasing there, but that's the basic idea. And so these would definitely qualify as arms. Now, in the Heller case, the anti-gunners had argued, well, it only covers muskets and flintlocks and matchlocks and other obscure 18th century firearms. Those are the only things. And as I said earlier, just as the First Amendment covers the internet and protects the internet, so too the Second Amendment covers arms, anything that can be carried for offensive or defensive purposes, but it does have to be commonly possessed by law-abiding citizens for lawful purposes.
So, David, I believe you've made this point before. I think you made it back in November when we sat on a panel together with Jonathan Lowy of the Brady Center, as I previously mentioned. And I think you made an interesting point about the role of John Adams, the attorney John Adams, one of our founding fathers. Before he became president, John Adams was one of our founding fathers and a great attorney in the city of Boston. And I think he talked a little bit about arms being protected or carried outside the home. Can you tell us a little bit about that history point there?
Well, John Adams, first of all, he carried a gun to school almost every day. He was so that tells you, and it wasn't just him. The first 5 presidents of the United States carried guns on a regular basis. Thomas Jefferson said to his 15-year-old nephew, "Let your gun be your constant companion." And so either there was a right to carry at the time of the founding, or they're all felons. Okay, there's no middle ground between those two, and they're not felons. They were law-abiding citizens. Now, John Adams represented the British soldiers from the Boston Massacre, and in his opening statement to the court, he acknowledged the right of the Bostonians, the Americans, to carry arms. And so that was an acknowledgement by one of our great founding fathers, one of our leading legal thinkers, and someone who exercised the right himself, that in fact there was a pre-existing right to carry arms at the time of the founding.
Great. David, so we've already seen, in light of the NYSRPA versus BRUEN ruling, we're already seeing noise from the usual suspect anti-gun states, the Californias of the world, the New Yorks of the world. We're seeing rumblings, of course, about how these anti-gun politicians intend to try to get around, really, do an end run around the right to keep and bear arms in various ways. They've talked about various subjects and approaches. Do you have any thoughts about how your best guess is that the anti-gunners are going to try to take away through exceptions our right to bear arms in these anti-gun states?
Well, I think for the right to carry, one of the things we all have to be on the lookout for are sensitive places. As I mentioned earlier in the show, there are some historical courthouses, legislatures, polling places where they were sensitive places and you couldn't have a firearm. But what I think these left-wing anti-gun jurisdictions are going to do is they're going to try to create a huge swath of their territory as a sensitive place. They're going to try to put buffer zones around schools and hospitals and government buildings and post offices and whatever, and parks. And there's no historical precedent for a buffer zone of any sort. There's no historical precedent for parks. In Fairfax County, in Virginia, right across the river from D.C., there's something like 20,000 acres of parks, and they've declared all of them a sensitive place. In D.C., in Washington, D.C., it's gotten so extreme that if you're within a certain distance of a motorcade, it's a sensitive place. Well, for anyone who's been to Washington, D.C., that's not a fixed event.
So, David, you made a reference to motorcades, and there is some discussion about the role of motorcades in D.C. In terms of being a sensitive place, which, of course, is a euphemism for gun-free zone. Tell us a little bit about those motorcades down in D.C.
Well, it's crazy because anyone who's been to our nation's capital knows they don't announce where the motorcades are going to be. And so you could be walking down the street and some motorcade comes out of nowhere Now you've got to start sprinting away from it. I mean, so they're making it, they're going to try to make it basically impossible to actually exercise this right. And, unfortunately, there's going to be have to be contestation and litigation about it. But the good news is, as long as this Supreme Court is in place, we should ultimately prevail. The bad news is, as you can see, it takes time. And this is not going to be instantaneous.
So, David, I read the BRUEN decision, and I thought it actually had some somewhat favorable language about gun-free zones or sensitive places. It seemed to me, if you look at the examples that this Supreme Court gave, both relying on Heller and this case, they talked about really places of government, essential government functions. They talk about polling places where you vote. They talk about state legislative chambers, which again is like the Capitol and state analogs to the U.S. Capitol. They talked about courthouses, and they talked about schools, which I think schools mostly in the United States, right as of now, are public schools, not exclusively, of course. But it seems to me, and then of course the court seemed to have gone on to talk about how you can't declare all of Manhattan, the island of Manhattan, a sensitive place. So perhaps you can talk a little bit about where we think they're going to go. We know they like to define all of America as sensitive place. Again, a euphemism for gun-free zones. But what do you think's going? What do you think about the language that you read in BRUEN that might be helpful to fighting back on overreach by the anti-gunners who want to take away our gun rights using these gun-free zone exceptions they're talking about?
Well, the most helpful part of BRUEN is the methodological framework it establishes. First of all, the text creates a presumption that the regulation is invalid, any regulation of a sensitive place. And so they're going to need to be able to identify, and the burden will be on them, the Supreme Court is clear, to identify a historical tradition dating back to 1791, dating back to the time of the founding, where there were limitations, where there were gun-free zones. And as you say, they really focus around governmental buildings like the courts, the Congress, polling places. They mentioned UVA in 1824, I think, at a time where Thomas Jefferson and James Madison were on the Board of Visitors, and they put in a ban on guns for the students, not for the teachers. So that's something to note as well. But basically, if the anti-gunners try to expand this to something that is not directly analogous to one of those types of situations, they're going to have a problem. And certainly things like parks and other things are not going to work. And these buffer zones that they're going to want to create too, because that will make it, the buffer zones are particularly pernicious, because even if they're able to designate a particular government building, let's say, as a sensitive place, you don't want to make it so people have to cross the street or can't drive by it, or, worse, have to walk a mile out of the way, whatever it might be. And that's what they're going to try to do. They're going to try to create all these places and all these buffer zones and strip the right that way, and we're not going to let them.
Well, that sounds like you've got some good arguments there in favor of the Second Amendment. I'm glad to hear that, David. Now, there's a couple other issues that I think are out there. What about taxes on guns? We hear these politicians sometimes talk about, I'm going to put a 10,000% tax on AR-15s and on ammunition. What is the story about taxing firearms and ammunition under the Second Amendment?
Well, again, the good news about BRUEN is look at that framework, that legal framework it established. It said you've got to find a historical tradition. To my knowledge, there is no historical tradition of taxing firearms and ammunition. Indeed, even today, it's only Chicago/Cook County and Seattle are the only two places in the country, to my knowledge, that have it even today. And at the time of the founding, there was nothing. And so those laws should go away. And the same for these hefty fees. In New York City, they want to charge an arm and a leg to get a permit. Those fees, to my knowledge, there's no analogy at the time of the founding. That should go away.
So, David, we've talked about one of the anticipated anti-gunner responses to the BRUEN decision to take away a right to bear arms, to carry guns outside the home for self-defense, is again, sensitive places, which is, again, just gun-free zones. But there are some other things that are being talked about, it sounds like. California apparently is discussing at least the notion that the state would be able to review your social media accounts. Maybe they'd be able to pick up all these phones and call your neighbors, get these personal references to make sure that you are a person of a good reputation, that you're not just a law-abiding American, but that you're also someone that would be, quote unquote, responsible as a gun owner, whatever that means. So, David, can you talk a little bit about any angles of attack that you could see the anti-gunners using to try to say that we don't have to just look at if you're law-abiding under the NICS system, we got to make sure that you're responsible as we, the anti-gun states, deem?
Well, Mark, I think you put your finger on it, and that directive from the California Attorney General was very telling, because not only are they looking to almost treat this like a country club or something. If you've got 5 letters of recommendation, you can come in. That's not the way constitutional rights work in this country. And so that's a big problem for them. In addition, they say in that California directive, they're going to look at social media posts to see if somebody, is prejudiced or is filled with hate or something like that. That's a violation of the First Amendment, okay? Because you have a right to say whatever you want. Obviously, you don't have a right to threaten people. That's another matter. That's assault. But short of threatening violence, you have the right to speak in this country, and they can't strip your Second Amendment right because you exercised your First Amendment right.
So, David, on this channel, we've talked about some of the anti-gun arguments that were advanced that the Supreme Court seems to have rejected. I just want to go through them quickly and get your reaction to what the Supreme Court said and were you persuaded. The first is the anti-gunners argued that there were these so-called surety laws in places like Massachusetts in the 19th century, and this somehow indicated that you weren't allowed to carry a gun. And I bring this up because these surety laws certainly have these overtones, or this feel at least, that they're a little bit like 19th century kind of red flag laws with a much different outcome. Any impressions on these surety laws and what we should know about them?
Well, it's the left is going to strain. There's so few regulations at the time of the founding that they're going to stretch decades beyond the time of the founding. Remember, that first surety law in Massachusetts came in 1836. So the founding 1791. So number one, they're stretching way out in time, number one, and then they're twisting and distorting history. And the good news is the United States Supreme Court is not going to let them do that. Those surety laws, were number one, were not bans. How can they point to them as a justification for their ban when they weren't even bans? Number one. Number two, those sureties laws destroyed their central argument. Their central argument was in Massachusetts, until 1836, there was a ban on firearms. And then if their version of history is right, that in Massachusetts in 1836, there was one and only one sort of person who could carry, which was someone who was deemed so dangerous that they had to post a bond to carry a firearm. Those two things couldn't possibly be right. So that's a good example of they stretch, they distort, they manipulate it. But when you get to the United States Supreme Court, you're dealing with very smart justices, very smart law clerks, and they are going to see through these manipulations, and that's exactly what happened here.
Yeah, it's very interesting, I thought, with those surety laws, which basically say that it seemed to me you have, and the Supreme Court seemed to agree with this, that you have a right to carry guns in the 19th century, and the exception was if you did something that appeared to be a threat to somebody else, and that person could go to the court, and they couldn't deny you the right to carry guns. They couldn't take your guns. All they could do is require you to post a bond, a small bond. And apparently the only example that even existing, according to the Supreme Court, they found one case, and in that case, the bond wasn't even required because the person wasn't viewed to be a threat. So I thought the Supreme Court really did a good job distinguishing the so-called anti-gun precedent of surety laws, which at the end of the day didn't appear to be particularly anti-gun at all at the end of the day. So David, let me ask you, go ahead, David.
Laws are not anti-gun, and you're right, the Supreme Court saw through these arguments.
So, David, the other thing is they talked about these Wild West territories, saying, well, in some of these Wild West territories, you weren't allowed to carry handguns. Can you tell us a little bit what the court said there and your impressions of that?
Yeah, I mean, the court looked at that, but again, it's very late in time. You're talking many decades after the founding. You're talking about outliers. This was a minority of jurisdictions, and for all of those reasons, even in most of the territories, didn't have these types of laws, and so for all those reasons, they were right to give it the back of their hand.
So, David, I just want to ask you a few more questions. We really appreciate your time today. It's been extremely valuable, and I hope our audience has learned a lot from it. I want to ask you to pick up your crystal ball a little bit and tell us what maybe you see in the future. Right now, as we're having this conversation, there's cases, that are potentially before the Supreme Court involving open carry out of California. We have two bump stock related cases, one of which I believe your firm is actually handling. And there's also some discussions of the assault weapon ban and magazine bans in some of these states. Looking through the crystal ball here, any thoughts about what maybe our audience should be looking at down the road of what the Supreme Court might take next, or what they may take in a year? Or what do you see happening with the Supreme Court?
Sure, there's a short term and a medium term. In the short term, over the next week, the court's going to decide whether to take a magazine case, whether to take an AR-15 case, whether to take the bump stock case. So we should know in the next week about those cases. So that will be very significant. In the normal course, they would probably send them back for reconsideration in light of what they've done in Bruin. And in that instance, it will probably take a year or two for the next case to come. If we win these cases in the Court of Appeals, I don't think the left is going to be racing to the United States Supreme Court to make, from their perspective, more bad case law. But if we lose any of these cases, make no mistake, we will be back at the United States Supreme Court. And I think we've got a great chance of winning now that we've got this Bruin majority.
So, David, I want to talk to you just a little bit about the bump stock cases. I mean, for those of you in the audience who aren't familiar with these, the bump stock cases before the Supreme Court, at least as I read it, they're not expressly Second Amendment cases. They don't expressly deal directly with the right to keep and bear arms. They seem to be much more about administrative law, which is really the law that governs these alphabet soup agencies, the EPA, the FDA, the ATF, the FBI, and so on and so on and so on. Can you perhaps talk just a little bit about these bump stock cases and what's really at stake with them, and why should gun owners care about these cases even if they don't own a bump stock or never owned a bump stock?
Well, there's a doctrine that the United States Supreme Court invented in 1984 called the Chevron Doctrine. And basically what it did is the court said, look, when an agency is arguably within the limits of its authority, then we're going to allow it to regulate however it wants. And that has been very empowering for bureaucracy, including the ATF, obviously not limited to the ATF, but the whole panoply of alphabet soup agencies that you referenced. And so this is an opportunity to rein that in, to say, we're not going to actually give you that deference. You're going to have to show that Congress conferred this authority upon you. And so it would be a very good thing for gun owners. I think, the Biden administration is always trying to increase the reach of the ATF, and to be able to harness and hold them in would be a good thing.
Yeah, it's interesting, David, that when the country was founded, we were supposedly, the federal government at least, were supposed to have three branches of government: the executive branch with the president, the legislative branch with Congress, which had two houses, the House of Representatives and the United States Senate, and then, of course, the judiciary with the Supreme Court at the top. Those were the three branches of government that were supposed to basically run the federal government and the national government. And yet somehow over the last many, many decades, we have this rise of the regulatory state of all these tens of thousands, as best I can tell, of unelected bureaucrats that seem to have jobs for life, and they get to set all sorts of policies involving our day-to-day life, policies that may be politically entirely unpopular, and yet our politicians are able to dodge the bullet. They can simply say, well, I don't have to take a vote on this question. It's because the EPA decided I have to follow them or whatever it is. It just seems to me that the politicians like these administrative agencies to some degree because it takes the heat off them and they can just blame some unelected bureaucrat who nobody knows who they are or where they even work or anything about them, and they're making these major policies. So what are your reactions to that, the Chevron doctrine, and how it might affect, let's say, the Bureau of Alcohol, Tobacco, and Firearms and Explosives?
Well, look, I've got bad news for you, Mark. It's not tens of thousands, it's hundreds of thousands. I can say that as someone who lives in the Beltway. And, you know, the deep state is a real thing in the sense of the overwhelming number of people at these agencies are career bureaucrats. You can't get rid of them, no matter how incompetent they might be. You know, you can look at the Bernie Madoff situation with the SEC. I don't even think those people were fired, even though they were asleep at the wheel. The point is, they're there. There are an enormous amount of them, and they're overwhelmingly Democrat. They're overwhelmingly trying to expand government. And as you say, they're totally unaccountable in many instances. They're so-called independent agencies. Independent means unaccountable to the American people. And so it's very pernicious.
So, David, one final question here, and then I'll let you say anything you'd like to say to our audience. The final question is this. We talk a lot about the Second Amendment on this channel, specifically the fact that the way the text of the Second Amendment is written is quite interesting because it seems to presuppose that the right to keep and bear arms already existed before the Second Amendment was crafted. Do you have any thoughts on whether or not the right to keep and bear arms is a pre-existing right that exists before the text of the Second Amendment was even conceived?
Yeah, 100%. You know, the Declaration of Rights of 1689 over in England was very explicit about this right. It was very important to that glorious revolution, so to speak. And Justice Scalia, now Justice Thomas, have been very eloquent in saying this is a pre-existing right. And that's why looking at the time of the founding is particularly important. They weren't writing on a blank slate. Everybody knew how this important was for self-defense and for all the other purposes that have been identified in Heller, McDonald, and now BRUEN. And this is just a monumental victory. It's a great victory for gun rights.
Well, David, we really, really appreciate your time here. Is there anything or any advice or guidance you'd like to give to our audience here today at the Four Boxes Diner? I know they like to, they tune in to many of my stories and vignettes and segments where we talk about not just the text of the Second Amendment, but the history and some of the scholarship that goes into it, some of the legal geek stuff that I think is important for ordinary Americans to understand because, of course, unlike other rights, the Second Amendment really is litigated nonstop, and there's a group of people that want to take our rights away. They want to confiscate the guns. They want us to be disarmed, and the courts and the legal process is oh so important to this right in a way it may not be for other rights. So, David, is there anything you'd like to leave or say to our audience before we sign off here?
There's an old saying from ancient Rome, ipsis geantia potestas est, which means knowledge itself is power. And so becoming educated about the Second Amendment, telling your friends, telling your children and your grandchildren, it's critical because if everybody understands the value of these rights, it's going to be much harder for the anti-gunners to strip them out of the U.S. Constitution.
Great. Well, David Thompson of Cooper and Kirk, we appreciate all your hard work on behalf of the Second Amendment. I know you've got a lot of cases going all across the country, and you've had for many, many years. And we all appreciate your support. We appreciate and we applaud you and we cheer you on, and we hope you much, much success in the future, vindicating all of our constitutional rights, including but not limited to our Second Amendment right to keep and bear arms.
Thank you so much, Mark. It's been a pleasure. Thank you, sir.
Orders up. Table 2A.